Welcome to Coastal Funeral Center and our Community Partnership series of videos on financial planning, trusts, and wills. My name is Sharon Kalani, and I'm the Director of Business Operations here at Coastal Funeral Center. Our subject today is going to be what to include in a trust. And our special guest to help us answer those questions today is Kristen Damon from the Law Office of Robert Palmer in the City of Torrance. Welcome, and I'm so glad you're here.
Thank you, Sharon, for having me.
My pleasure. So we'll get right into it. What should someone include in their trust?
It's a great question. So I think we should start with why people have a trust, which the number one reason is to avoid probate. And the only way to avoid probate when it comes to real property is for it to be in a trust. Not entirely true. There is another option called a transfer on death deed, but that's really not a good option for most people. It doesn't allow for contingent beneficiaries. So most people could go with the option of setting up a trust to include their home and any rental properties in California. You can also have properties in different states, but it's important to talk to an attorney that's licensed in the state where the property is to see if that's the right option for that property. When it comes to financial assets, there are two options to avoid probate. One is to include a transfer on death or payable on death beneficiary. The other option is to put it in the trust. So it depends on what your objective is with that asset. If you have minor beneficiaries, then that asset should go into your trust, or the trust should be the beneficiary on that asset. But if you have adult children and a spouse that the asset's going to go to, it may make more sense for that asset to just have a beneficiary designation. Outside of that, we have life insurance policies. Typically, you're not going to put those into a trust unless it makes sense for tax purposes, if you're going to have some sort of advanced planning, such as an irrevocable life insurance trust, for example. Otherwise, a life insurance policy typically just has a spouse or a relative as a beneficiary, but it can have a trust as a beneficiary. Outside of financial assets and life insurance policies, the other thing people want to know about is, should their car go in a trust? Typically, the answer is no. That is an easy transfer on death form that can be done with the DMV when your loved one has passed away. So unless the car is of an extremely high value, it's a collector's item, it's worth several $100,000, it doesn't necessarily need to go into your trust.
What would be a sample dollar amount? Is that $100,000? Is that $50,000 for a vehicle, for example, or a piece of furniture, a piano?
Yeah, so it's a great question. So the smallest state limit right now is $184,500. Yes, and so if you have an asset that would otherwise be subject to probate, but is under that amount, and this is a combined amount, then it can be collected through a small estate affidavit, and that includes cars. So if you're talking about a car that's worth over that amount, I would recommend assigning it to the trust. And some attorneys will do a general assignment of all personal effects, including cars, to the trust. Oftentimes what we do in our practice is recommend clients write a letter of instructions of what they want to happen with their personal effects. Because those are the things that ultimately get fought about a lot, especially if there's a sentimental item, a car that you worked on with your dad, or a piece of jewelry. There's just one of it, such as a wedding ring. So those are things that you want to have the client write a letter of instructions of who should get what to prevent any fights. But in terms of the court, the probate court, they're not very concerned about those personal effects unless there's going to be a probate of other assets, and then those cars and jewelry and wine collections get lumped in. So having a general assignment to your trust can take care of that.
So the general assignment would list those items like a piece of jewelry passed down through the ages, and that's an attachment to the trust, or?
Yeah, so an assignment can be just kind of standard boilerplate language that says all of my personal effects, including anything that's tangible. You wouldn't necessarily have to list the item specifically, but it does help for it to be specifically listed, especially if it's going to go to a specific person. But when all you have in your trust is your house, maybe a brokerage account or two. Oftentimes, just a letter addressing those personal items is enough to take care of the estate when you've passed away. As long as nothing else is going into probate, those items don't need to be included in the trust.
You mentioned a brokerage account.
I did.
So if you have an account that has more than the $185,000 in it, that should go into the trust.
If it doesn't have a beneficiary designation on it, then yes, it should go into the trust. And there's also another reason why it's helpful to include a brokerage account or a savings account, some sort of financial account in the trust. If you have financial assets that have beneficiaries designated, and they're different than the beneficiaries in your trust, and then you have this home that you owned that now needs the trustee to be able to pay the utilities and the gardening and property taxes, and there's no other cash assets in the trust because they all went to other beneficiaries, that can be an issue. So it's helpful to at least have one account in the trust, if not all of them. And certainly for ease of administration, having everything under one umbrella really helps the family, the trustee, manage everything, and it's not managed by multiple people.
When you say that at least one account should be in the trust, I know that often when banks find out that account holder has passed, they'll freeze the account.
That's absolutely true. So if it's in the trust, however, then that doesn't happen. The bank just needs paperwork showing who is the successor trustee. Just a very simple form called a trust certification. A lot of banks have those forms that the person can fill out, or if they're working with an attorney on trust administration, we would produce that trust certification. And then they can take that to the financial institution and get added onto the account as the successor trustee and have immediate access. They're not waiting for a death certificate that would otherwise happen if the account's in the person's name alone.
So the intent is to put the brokerage or the one checking account in the trust, but they never go to the bank and actually change the name from their personal name to the trust. Then it's a different story.
So often trusts have a Schedule A, which is the list of assets in the trust. If you have that account listed on the Schedule A, but it's not titled in the trust with the bank, it doesn't matter to the bank that it's listed on the Schedule A. So the only way to change title on the account, make it a trust asset, is to go to the bank and take care of it with their documentation and whatever they require. And it's different for every institution.
Right. And I think you mentioned this before, that includes the property. Just because they say the property's in the trust, if they don't go physically change the ownership of the property to the trust, it's not.
Absolutely. So most trust attorneys in their trust package are going to include a deed to transfer those properties into the trust, and they will make sure it gets recorded, public record, it can be found in a title search, there's no issue of titling. But if you're doing your own trust, you want to make sure you take care of that change of title for your deed as well.
What happens if you have minor individuals that are beneficiaries of that trust?
It is great when you have minor kids to make your assets either trust assets or the trust the beneficiary of those assets, because those minor children can't inherit until they're 18 under California law. When they're the beneficiaries through the trust, then a successor trustee can manage the assets for them. And you've probably covered this before, but it is important to put provisions in your trust about when children should get access to those assets outright. It can be used for their benefit prior to a certain age, and maybe you stagger distribution for them. So let's say you have a brokerage account, it's in your name alone, and you have your spouse as beneficiary, and then you name your kids as contingent. Well, if your kids are minors, that's going to be an issue. And that's where you want to put that sort of asset into the trust. If you have a retirement account, you want to have your spouse as your primary beneficiary if you have a spouse. But if you have minor children, you probably want to make the trust the contingent beneficiary. There can be some administrative and tax issues that come from having a trust as the beneficiary of a retirement account. So it's not what we advise if you have adult beneficiaries, but when it comes to having minor children, that is the best option.
One thing that we discussed a little earlier, and I'd like you to share it with everyone, is about interment rights, or some people might refer to it as burial property at a cemetery. What happens with that property if it's not in a trust, if it's not listed in the trust?
Well, if it's not listed in a trust, it can be a probate issue if it's over that certain amount. And also, I learned from you that funeral homes won't always recognize a pour-over will. So those rights will have to go to the next of kin. So it's important that you either title those rights in your trust with the funeral home or that you list it specifically in the trust.
Well, thank you so much for joining us today. And our goal is to be educational to the community. And if they had any additional questions, how can they reach you?
Oh, thanks for having me, Sharon. They can absolutely reach me at my office at Rob Palmer Law. I can be reached at 310-373-6831 or by email at kristen@robpalmerlaw.com.
Thank you again for joining us today. We're grateful you were here. And thank you to all of you for watching today. If you have any questions for us here at Coastal Funeral Center, you can reach us at area code 310-326-6343, or you can reach out to us on our website at coastalfuneralcenter.com. Thank you.